Committee will come to order. Bill.
Mr. Chairman, I ask unanimous consent that the subcommittee permit the meeting to be covered in whole or in part by television broadcast, radio broadcast, and/or still photography pursuant to Rule 5 of the committee rules.
Without objection, persons requested agreed to. Today is the second day of the subcommittee's hearings on H.R. 1131, entitled the Copyright Remedy Clarification Act, and on the Copyright Office's report on sovereign immunity in copyright cases. At our first hearing, we heard from the Register of Copyright, Ralph Ullman, who told us of his support for the bill because it simply clarifies what Congress intended in the 1976 Copyright Revision Act, in his view, that if states infringe copyrights, they should be held fully liable for money damages as well as other relief. Since our last hearing, the Supreme Court has decided the Union Gas case, and indeed 4 other sovereign immunity cases. The court held that Congress is constitutionally empowered to abrogate the 11th Amendment pursuant to Article 1 of the Constitution. Since the copyright laws were under Article 1, I see no constitutional obstacle to our proceeding with this legislation. Our witnesses today will help us to decide whether, from a policy standpoint, we should in fact proceed with H.R. 1131. There's still many issues to be decided. We may be asked to revisit the overarching issue of whether abrogation of sovereign immunity is appropriate in the circumstances before us. And even if we determine that abrogation is appropriate, we must still review suggestions that certain remedies that the copyright laws impose on private parties may not be appropriate for state institutions. Before any consideration of these issues, however, we must be sure that the language of 1131 is sufficient to indicate a clear and explicit congressional intent to abrogate sovereign immunity. The Supreme Court's requirements on this issue are stringent, and we must adhere to them as precisely as possible. It is for this reason that we have added to our witness list an expert on the issue of sovereign immunity. She has provided critical advice on a redraft of H.R. 1131, which I believe now meets the Supreme Court standards and which has been circulated to our witnesses today. In any event, I look forward to the discussion today of these and other important issues relating to the bill. Gentleman from California, have any opening statement?
Well, Mr. Chairman, since this is the second hearing on this subject, I don't have a prepared opening statement, but this is a very important subject, and I note that with people here representing some of our universities from California and elsewhere, the opening remarks of Senator DeConcini on S. 497 was that the result of these decisions is that public universities can infringe without liability upon copyrighted materials and essentially steal information from private universities, but private universities cannot similarly infringe with immunity on public institutions. In other words, UCLA can sue for copyright infringement, but UCLA cannot sue UCLA. As a graduate of both schools, I'm kind of interested in this kind of an outcome, and I hope that our witnesses today can clear up the point for us and we can go forward with this legislation.
If there are no other comments, we will introduce our first witness. In fact, our first witness today, as I mentioned, is an expert on the issue of sovereign immunity. Carol Lee is a partner at the law firm of Wilmer, Cutler & Pickering, studied and written extensively about sovereign immunity. Grateful to her for extensive advice about redrafting the bill we had before us, and indeed for her testimony today. Lee, welcome to the subcommittee.
Thank you very much, Mr. Chairman. Mr. Chairman and members.
All the other copyright questions we've had in recent history.
Thank you very
Look forward to
much.
seeing you again, Barbara.
Thank you.
I'd like to now introduce our first panel. Our first panel today consists of Meyer Cutts, the Vice President of Scientific and Technical Publishing Division of John Wiley & Sons, and Bert P. Vandenberg, the President of BV Engineering Professional Software. Mr. Cutts is testifying on behalf of the Association of American Publishers and the Copyright Remedies Coalition, and Mr. Vandenberg is here on behalf of the Software Publishers Association and ADAPSO. Both of you, we certainly welcome to the subcommittee. I would like, well, Mr. Cutts, you can go first if you like, and then Mr. Vandenberg, however you keep it.
Mr. Chairman, I have a statement on behalf of the AAP and the Copyright Remedies Coalition to enter into the record. I would like to direct my remarks to the economics of college textbook publishing to set the discussion into a business person's context. I'm not a lawyer. I'm a businessman. I was trained as a mechanical engineer, in fact, at MIT, which is a land-grant college, and how that, whether that would be more like USC or UCLA, Congressman Moorhead, I haven't any idea. But I do know that I was an author of 8 books. Thank you.
Thank you. Now, Mr. Vandenberg.
Mr. Chairman, members of the subcommittee, my name is Bert Vandenberg, President of BV Engineering Professional Software. Thank you for giving me this opportunity to testify in support of H.R. 1131, the Copyright Remedy Clarification Act of 1989. I think this legislation is necessary and should be passed as quickly as possible. With your permission, I will summarize my written statement in explaining why.
Without objection, your written statement will appear in the record as well as that of Mr. Cutts.
My company, BV Engineering Professional Software, or BVE for short, is a California-based publisher of microcomputer software. For several years, BVE was involved in a dispute with the UCLA about copyright infringement. The Ninth Circuit Court of Appeals ruled that because of the 11th Amendment, UCLA was immune from liability for monetary damages in copyright infringement suits. Now, UCLA has its own version of things, and we don't agree on much. But I'm not here to re-argue those facts. I'm here because I was never given a trial to consider the merits of the case. I wasn't given a trial because the state of California invoked the 11th Amendment. I think this is unfair. There are many men and women in this country who have invested their time and energy in creating art, music, books, and other forms of intellectual property. Our need is the same: effective protection against the theft of our works. Effective protection does not exist if some groups can violate your copyright without being subject to monetary damages. It's hard enough to find proof of violation, even when you know it's happening. Piracy is like, to me, getting your paycheck and then being mugged on your way home every payday. Injunctive relief is not enough. Injunctive relief prevents further infringement but does not provide any compensation for past copying. The framers of our Constitution recognize that creative artists need special protection in order to give them the freedom and the interest to share their works with the public. The framers did not intend to force artists to distribute their works without compensation. This is what will happen, however, if H.R. 1131 or other equivalent legislation is not enacted. After these recent court decisions, I believe many state agencies have decided that, in a sense, copyright statutes have been repealed for the states. H.R. 1131 corrects that erroneous perception. This bill makes it clear that when Congress drafted the 1976 Copyright Act, it intended to include the states as well as private individuals in every section. Anyone means anyone, including the state governments. I'm convinced that companies may not have any incentive to develop new programs if the question of sovereign immunity is not resolved in favor of the copyright holder. The United States leads the world in the development of innovative, productivity-enhancing software. The best software is created and maintained through careful research and development. And R&D is expensive. So anything that affects a company's cash flow necessarily affects R&D spending. When our best products can be easily stolen and no effective recourse is available, it is not difficult to see how software companies might lose the incentive and the ability to invest in more R&D. I also ask about the message that we're sending to our foreign competitors and foreign governments. The problem of software piracy is much more serious beyond this country's borders, and the course we set for ourselves is the course that many other governments may follow. How can we ask foreign governments to strengthen their intellectual property laws if our own laws say that it's acceptable for state governments to ignore copyright without fear of monetary damages? I urge you to vote favorably on H.R. 1131 and solve this problem for the copyright community. Thank you very much.
Thank you, Mr. Vandenberg. You've indicated, of course, Mr. Vandenberg, in your own case, you've already had a negative experience in terms of UCLA. I'd like you, either of you, to sort of generalize what you see industry-wide as the financial consequences, let's say, to the copyright industry if the 11th Amendment remains a bar to money damages.
Mr. Chairman, I wish I could give you I can only tell you what my opinion is because our company is very small. We're only 5 people, and I don't have the information that you're requesting. My feeling is, however, that, and it's already happened to me, that the prices of products are going to go up and the incentive to produce products are going to go down. Did I answer your question?
Yeah. Mr. Kutz?
Well, I certainly would agree. As I tried to indicate, we are presently in a highly competitive situation as it becomes more expensive to be in textbook publishing because unit sales are declining. There are price barriers. You can't price up infinitely. It will restrict competition. It will make for fewer textbooks, in particular in virtually any subject area. And really, the government and its citizens will be the losers.
Let me ask you whether there are any number of governmental entities with which your companies currently deal, that are state entities or state governments, who in fact you have contracts with and do recognize and pay you, irrespective of whether they might seek refuge in the 11th Amendment. Do you have a number of contracts with the people who, I'm talking about state entities, that do in fact pay you fully and do not resist, even though they theoretically might have a refuge in the 11th Amendment?
It would be my understanding that there would be academic libraries, public universities, state libraries that do pay to the CCC for making copies. So that I would think there are many of those kinds of situations.
Where current contracts are in fact fully honored?
There is an implied contract, or there are transactions.
Is that also, Mr. Vandenberg, true in your industry?
In my industry, the computer software business, it's not a commodity product that's used up, such as other products may be, and we find that we don't often sell multiple copies to state universities. No. We have sold multiple copies to federal government agencies, but not to state agencies.
Thank you. I'm going to yield to the gentleman from California, Ms.
like to ask both of you about what percentage of your business goes to state governments or their subsidiaries.
I'll answer that first. I have the data as to what goes to educational institutions because I looked it up. I did not break it
But
down
since
to
there's a
state.
difference between the private and public institutions as to the enforcement of this law,
I honestly don't have that information, but I can get it for you.
I just wondered what you feel you're losing as far as your sales to, say, a state university would be. What percent of the sales that you now have would you be able to increase if you got all of the payment that you're entitled to?
Thank you for the opportunity to answer that question. I think that the question is a good question, but I'd like to rephrase it a little bit, if I may.
Sure.
What do I lose? It's not just the percentage. BV Engineering produces relatively low-cost software, and we're working on about a 30% gross profit margin, of which half of that goes back into R&D for new products. So my net, what I get to take home and spend on my children, my family, is about 15% of our gross. I ask you, what happens if only a 10% increase in my gross sales? I get to take home almost double. So I'm saying a very small increase in our sales would result in a significant increase in my own personal income.
Are your experiences about the same?
Well, I understand the statistics are that I think it's 79% of undergraduate college students are at state universities, which means that for the college textbook business, that's a very high percentage. In addition, of course, many academic and state libraries exist which buy our products. So it's a considerable part of the market for publishers in general. And of my company in particular, I would hazard a guess it's around probably 30% of our sales.
Thank you very much.
Gentleman from Illinois. Singh.
Well, I suppose I should understand some of these abuses a little better than what you're giving it to me. So get a little fundamental with me, okay? One of you are talking about textbooks, the other about software. Literally, what do some of these libraries and school districts, what do they do? Just literally photocopy everything? Is that where your losses directly come in? Give me some of the practical things of what's happening out there. I can understand percentages you're talking about that, but what exactly are these people doing? You don't need to hesitate to tell us what, in fact, things are happening. I'd like to have a little bit more basics of what's going on out there and how they are deliberately trying to get around paying the just fees that I also think you have coming.
In 1986, I sold the University of California at Los Angeles one copy each of 7 different products. And we discovered later, by the university's own admittance in the deposition process, the university made a combined total of over 91 copies of our programs and documentation. I consider that pretty blatant.
So in other words, you got a computer software program and they just,
copy it.
duplicate it, and whoever at the university wants it or needs it, they just automatically get a copy of it.
I don't know what the mechanism is. All I know is that you take a computer disk, a 50-cent computer disk, and you can take a $100 program and make a perfect copy of it in less than 60 seconds on any personal computer. It's not. It's
Yeah, how
in
does
the
that
textbook
relate?
market. At least you have to use a photocopier and stand there for half an hour.
Going to the textbook, going to the textbooks, that's basically what is done. Is that
Well, it's not necessarily even copying the whole book. You can create anthologies by taking chapter or two from one book and a chapter or two from another book. Where you're going to lose sales then is you're deprived of the opportunity to reissue, let's say even a general trade book as an inexpensive paperback that would be bought as supplemental reading, or a book that would be bought in multiple copies by a library and put on reserve by a professor. So you're facing economic loss that's somewhat more complicated, but it's very clearly there. These are situations which we encounter and are attempting to deal with now very, very frequently.
Congressman Sangermeyer, I've been reminded that perhaps you might be interested in hearing about a specific situation, about what happened. When we found out that some copies were being made by UCLA in this particular case, I contacted the individual directly. I did not go to an attorney. I did not contact the university or the university attorney.
Situations which we encounter and are attempting to deal with now very, very frequently.
Congressman Sangermeyer, I've been reminded that perhaps you might be interested in hearing about a specific situation, about what happened. When we found out that some copies were being made by UCLA in this particular case, I contacted the individual directly. I did not go to an attorney. I did not contact the university or the university attorneys because in my previous employment with General Dynamics, the rule was that if you pirated a copy of a product, that you were fired. There were rules there. They did not want to subject themselves to lawsuits. So I contacted the individual directly because I could at least give them an opportunity to put it right. The individual initially denied having made the copies and, in fact, challenged me to produce the name of one person who had a copy. And so I did, because I had the information, just purely by accident. One of our authors was going to graduate school and saw it. And at that time, he became very abusive, talking about not only me, but software companies in general as being greedy and so forth, and threatened to return all the products and demand their payment back. So not only were we not going to get paid for the copies they made, but we were going to lose payment for the copies they had already purchased legitimately. These type of things happen because we're such a small company. I spend a significant part of my time on the telephone. These things happen with regularity. People call up. They not only will copy the products, but they have the gall to call in for technical assistance because they may not have a manual. And when you start asking them about the serial numbers in their name, the phone goes click. This is a constant reminder, a constant irritant.
Congressman Sangmeister, I should amplify on previous comment. The publishing industry created the Copyright Clearance Center in response to the essentially directive, the Copyright Act, that we balance the rights of copyright holders and users and give users of intellectual property an opportunity to make copies and pay for them in an orderly way. But in an atmosphere where there were not a bill such as the one being considered, we've already seen that state institutions, libraries, which were part of the Copyright Clearance Center, which were willingly paying for copies that they made, primarily of articles from scientific and technical journals, withdrew, were coaxed back into a pilot project that we're doing, but it would upset the balance that has been created to enable us to market journals at a reasonable price, at the same time giving users the ability to make copies of articles when they saw the need to do so.
Okay, so you're talking more from the standpoint of articles and magazines and periodicals, because when you use the term textbooks, I think of the standard college textbook by John Doe on physics. Okay, the professor on that particular course says this is what we're going to use as our basic text. When I went to school, you either went to the used bookstore and tried to buy somebody's copy from last year, which I guess you cannot really stop that.
Correct.
But if you couldn't buy it there, you went to the bookstore at the
That's
college
correct.
or other, and you bought the text. That it really hasn't
Well,
changed.
that is in some danger. Either the entire text could be copied, which is a time-consuming process, but could be done. What happens is you could put 1 or 2 copies on reserve in the library, and then students could go in and make copies of a few chapters for the next few weeks' time in the classroom, come back in and make copies of the next few chapters, etc. There's clearly an economic harm element present in such a scenario.
Of course, one student could buy the book for 10 others and go out and individually copy. I don't know how you'd get a handle on it. I mean, that could be
Well-
very well unlawful, but enforcement of it, which is a very difficult thing in your field, but I could see where this bill would help. That's all the questions I have.
Thank you. Yes, I appreciate your testimony. Actually, part of the testimony certainly of Mr. Vandenberg touches on a general software problem quite apart from this immunity problem that we're having in terms of giving effective protection to software, and some issues are raised which may be the subject indeed of another hearing. But we appreciate the testimony of both Mr. Cutts and Mr. Vandenberg. Thank you both.
Thank you.
Thank you.
Our last panel this morning consists of